Okay, thank you, Michael Trust, for joining us. I really am honored to introduce him. So Michael has been an HR executive for many, many years, and then knew that he wanted to help people even more. And so he got a law degree and launched his practice, employment law practice. And we've always had so many people ask questions about employment law, especially as they're coming in or exiting or anything in between. And so, what we wanted to do is to make sure that we provided an expert here that, will give us some great pearls of wisdom and great insights, and then be a resource to answer questions that you may have. So, Michael, with that, I'm turning it over to you.
Hi, thanks, Christy, and thanks for inviting me to present today. So for those of you that are not in California, this presentation is more or less focused on California, but there's still something in here for everybody. So some of this may sound a little foreign to you because, as many of you in California know and can appreciate, this is a different country. You just don't need a passport, right? So with that, let me start the presentation. And the point today here is to and Cindy, I'm not finding that that little link there. Can you see the screen?
Yep,
We
you're
can.
perfect, and
Okay,
it's in
perfect, great.
presentation mode.
Okay, thanks. So of course, being a lawyer, I have to tell you, this is not this is just a general overview. It's not comprehensive about anything. And of course, there's no attorney-client relationship formed by this, and it's for informational purposes only. So please consult with an attorney if you have a specific question. Cindy and I discussed that we're going to run through this pretty quickly to leave a lot of time for questions because Cindy thinks you're going to have a lot of questions. So with that, let's run through this. So we want to cover some things that apparently come up kind of frequently in the boot camp questions. And so things like offboarding and onboarding. And so when you think about the onboarding and offboarding, this tells you a lot, especially the onboarding, tells you a lot about the culture of the organization. So are things clear? Are expectations set? What does the organization do pre-culture? Is there good communication? And then with offboarding, does the organization and do you think about security and data loss and data breaches and reputational harm and any kind of compliance issues? These are huge issues, especially when you have some employees who may be disgruntled. So we want to think about those things. In terms of numbers, many in the boot camp or alums of the boot camp, we were all unemployed at some point. This is the most recent data. It's a little bit dated and it's pre-tariffs. But there were 7.6 million openings and 5.4 million separations. You can see the data there. We saw Procter & Gamble this week announce 7,000 layoffs. We saw Disney announce 4,000 layoffs. We saw Microsoft announce some layoffs. And so today's economic news is that there were about 37,000 jobs created last month, which beat expectations, but that's down from the peak when people were seeing 150, 250,000 jobs a month. And the tariffs, of course, there were significant tariffs put in place this week. So we would expect that there's going to be more layoffs and likely a recession sometime this year. So this colors the whole job search piece. I've experienced this. All of you have probably experienced this, and we thought this would be a great topic to talk about. So look, ageism exists. It's very real. It's illegal, but it's very hard to prove. So, we've all heard these tricks: slim down your resume, dye your hair, dress younger, be more hip. A lot of these things still don't work, but you can try them. This is very, very hard to prove if you don't have a smoking gun. An email saying you're too old, or we want a younger crowd in our office. We want the tech bro culture, which is sort of code for young, energetic, which are all problematic. But this is probably the hardest type of discrimination to prove unless you have that smoking gun. So you can use statistical evidence if you can get it to prove this. But an employer or a would-be employer, so an applicant or somebody being terminated, they'll come up with some plausible non-age related reason for terminating somebody or not hiring somebody. It may not be credible, but that's not enough. So It could just be we had a better qualified candidate. It could just be it wasn't a good culture fit. Another code for we just don't want you. Um, as many of you saw, probably, I think it was 3 or 4 weeks ago, there's an executive order at the federal level that disparate impact no longer has the same weight that it once did, which takes away some of the statistical um, analysis. In California, we still consider that, but and there is an age discrimination law in California, but the law that most people use is the federal ADEA, Age Discrimination and Employment Act. And so if you're in federal court, this could start to become a problem about the disparate impact analysis. And age issues have to be the primary motivating factor. So just because they are a factor doesn't mean there's age discrimination. It has to be a primary motivating factor. And again, that is going to be difficult to get data to prove unless you've got some kind of whistleblower inside who can get that for you. Stray comments. Hey, Bob, when are you going to retire? Probably not enough. Some courts disagree. This analysis is going to be very, very fact specific in terms of what was said or done, who said it, when, what the context was. Again, I would say probably not enough if it's just a stray comment. And there's a myth that, well, if they hired somebody younger, it had to be age discrimination. Yeah, not necessarily. So some courts take it further and say, well, how much younger was the person? And some say, well, let's look at the last 10 years. And some employers get around it by simply just saying, we're going to hire somebody 40 or older. Therefore, by definition, there can't be age discrimination. Not necessarily true, but this again is not enough. This is a very hard claim to make. So if you can make out the case, this is the McDonnell-Douglas burden shifting test for those of you that have done HR before. The burden shifts to the employer. If you can make out what's called a prima facie case, that there's enough to make a claim here. If they can show a non-biased reason for that action, then the burden shifts back to you to rebut that. And again, that's where it can be difficult. Again, it's not impossible, but it can be difficult. So it depends on the employer, it depends on the data you have, it depends on the quality of the witness, and of course, everything is fact specific. So let's pivot to sort of what everybody's talking about these days, mental health in the workplace. So we have 5 generations in the workplace now. All 5 of those generations have very different views about what a work ethic should look like, what a professional ethic should look like, what decorum should look like. And so particularly with younger generations, we see that criticisms are often taken as personal attacks. And there's sort of this mental decompensation happening when those of us that are older are just looking at them like, what's wrong with you? Like, what are you talking about? So companies have got to have a good mental health crisis response plan, which could include an EAP, protocols for calling 988, which is the National Suicide Prevention Hotline, debriefs with staff after an incident. Of course, you're not going to share any personal information. You're looking for things like panic attacks, which are becoming very frequent, especially among younger generations. The obvious ones, threats to harm self or others, and severe disorientation. I mean, there's others, but these are sort of the big ones. And it's important for leaders to impart that criticisms, as I mentioned a minute ago, are not personal attacks. They're designed to help somebody improve. And we see that people that take criticism well tend to improve, and people who don't tend not to. Now, that criticism should be constructive. It shouldn't be belittling. It shouldn't be demeaning, condescending, patronizing, all of those kinds of things. That's just common sense. But we don't have a lot of common sense in the world today. So pointing it out. But again, the younger generations seem to really take everything very personally, and so this is driving a lot of these mental health issues. So in the workplace, think about hidden barriers to mental health. Are your benefit plans robust in terms of what they offer in mental health? Do they go beyond what's required under the Mental Health Parity Act, which, by the way, is now under attack and may go away? Do you offer in-house support? Do you have an EAP if people will use it? All these kind of things. Interesting. In a place that I've done some work, there was an EAP because the employees asked for it, and then nobody used it and had never seen anything like that. And so they said, we're not paying for this anymore. No one's using it. We're not going to pay for it. So that was that. Are there penalties, whether they're explicit or implicit, for taking time off for whatever reason, for vacation, just a lack of a better word, a mental health day, just need to catch my breath? Is that encouraged or discouraged? If people are burning out, are managers and leaders trained to say, let's adjust your workload a little bit while you catch your breath, get caught up, and then we'll come back and revisit this without, of course, burning out the people that have to take on the work. Policies are great. Lawyers love policies because we can point to the policy and say, this is the company's policy and practice, if it is their practice. But the reality is policies often say A and practices often are B. And that becomes a problem in general. But here, particularly when you're talking about mental health, yeah, we talk a good game about work-life balance and about mental health and everybody being supported, but it's really a sweatshop at the end of the day. Well, that doesn't really help anybody. And all of this rolls into, is there support for people? Is there some place for them to go internally or externally that is safe for them to express whatever they're feeling, not necessarily clinically, although it could be if you have that kind of qualification, that can get people to be more comfortable and to get over these challenges. Mental health is driving a lot of employment claims on the plaintiff side these days. Now, in California, the good news is, unless it's really egregious, and there are some carve-outs, they're not a lot, this is going to fall under mental health. So as an employer, you're in this limited universe generally of workers' compensation where there's not going to be a $5 million nuclear verdict against you. But you are going to have people out of work, which means work isn't getting done. Your rates are going to go up for this. It's going to, other people in the firm or the office or the organization are going to talk about it. And so, these things tend to snowball if they're not contained. So easier to sort of address it on the front end than to address it on the back end. So one of the things that we're seeing, and particularly now, there's just so much uncertainty with tariffs and what the economy is going to look like. And, we see all these layoffs happening again, and nobody's really, and, the cost of living is high everywhere, particularly in California, but everywhere. There's a disconnect between what employers see as their really stellar comp and benefits plans and what employees perceive those plans to be. And I think there's going to be a reckoning here at some point about, companies can't afford to give away the store. I mean, right, they're in business to make a profit unless they're a nonprofit, and that's their goal. But you can't do that without good people, and good people require good pay and benefits. So there's going to be some disconnect here. And if pay goes up and benefits increase, then we have more inflationary pressures, and then we get into this cycle. Like we saw a little bit in the pandemic when, every candidate had 6 job offers and everybody was outbidding everybody else, and we saw what happened. So this isn't going to change tomorrow. With the layoffs happening, employers still have some advantages, but for people that are really highly skilled and unique and specialized in what they do, they can command what they need to command. So to address these things as leaders, you want to build your personal skills and your emotional intelligence. Take workshops about stress management, mindfulness, deep breathing, emotional regulation, very key again, because a lot of these younger people take things very personally. So learning how to regulate your emotions and how you deliver a message, and teaching them how to regulate their emotions when they receive a message or criticism or whatever. Like, it's not the end of the world. Slow down, take a deep breath. And of course, resilience. We've been talking about this for years, about resilience. And then, into onboarding, if mental health is incorporated into training as people go through onboarding in your organizations, it sets a strong foundation for new employees, especially, again, everybody, but especially the younger workers who really do prioritize workplace well-being. They won't stay. And we all know that turnover costs a lot of money, and in training, in time, in stress, and on the rest of the staff, everybody. So we tell people at the beginning, this is how we operate, this is how we do things related to mental health here. We want our people to be happy. No one's ever going to be happy all the time, of course. There's no utopia here, but we take this seriously, and we want you to use the resources that we have. Then we can build that into the culture of the firm. We can minimize those claims of wrongful termination, workers' compensation, discrimination, harassment, all of those kind of things, because frankly, in a healthy organization, those things aren't going to be tolerated. And then my favorite topic, and Cindy, we didn't talk about this, but I added it when we had our conversation last week. This really could be an entire presentation. So for those of you in organizations, California has laws around this now. They're getting ready to strengthen those laws. It's going to pass in the legislature. There is some opposition to some of it, but the crux of it is that if AI is going to be used in any way to hire, fire, screen, um, make comp and benefit decisions, do performance evaluations, or contribute, there are going to have to be a lot of safeguards in place. There's going to have to be human interaction before those final decisions are made. So California is rightly concerned about AI having its own internal biases because it's trained by humans who have biases, and AI doesn't have the capacity yet to really think about in the moment like a human could. Hey, is this right? Is this wrong? Right? Should I be asking these questions? Should I not be doing this or that as I make this evaluation? So you can use it. It just has to have safeguards. And of course, with AI, we have to think about things like confidentiality, trade secrets, intellectual property, all of that, because if you use a public uh, one like ChatGPT, everything you put into it is going into its large language model, and it can use that data for anything. If you buy an enterprise version of things like that, then you can set it up so it's a closed universe that only you can see. You've got to be careful about using anything in the public domain because that data is going to be shared with other people at some point as some type of learning or some type of output. Um, I use AI every day in my legal practice for clients or anything that's legally related. I'm in a closed universe that's very expensive for AI. It's fantastic. It makes my life a lot easier. Um, but anything I'm doing that I don't, there's no privilege, there's no confidentiality, anything like that, like marketing, I might just use a commercially available AI tool because I don't really care. If it wants to learn from my marketing, it doesn't matter to me. So, but we want to be careful about this. So if you're putting in to ChatGPT or a, Claude or any of the others, hey, I want to fire this employee. This is what they did, and it's all public. That could now be discovered and could be used. So what's happening now, a lot of companies are doing interviews one way with AI, which is a little bit unnerving because there's really no feedback that you would expect in an interview to sort of course correct or are you on the right track? And some are now doing it two ways, where there's a video, there's an AI, and there is some level of feedback. People are sort of, I think some people are into it, and some people are kind of like, yeah, I'm not going to interview with a company that does that. I just don't think that's the right way to do it. It's coming. It's happening. It's going to happen. It saves so much time and money. Personally, I'd rather just interview the person in person, get a feel for them, but I'm in the minority. So as you think about hiring people, AI can generate a resume to say anything now very quickly in a matter of minutes. And so what's happening is you go on LinkedIn, you go on Indeed, whatever, you see that 10,000 people have applied for a job. But a lot of those are just AI generated resumes where someone took a couple of minutes, popped in their resume to an AI platform, put in the job description and generated, and they applied, even though they're really not qualified for the job. And what's happening now, we're hearing from recruiters, is that they're not finding the good people because there's so many resumes to go through. They can't tell what's what. I mean, there are certain tells on AI, but even so, you still got to go through them. And then, of course, you have the AI and the applicant tracking systems. And you may not have seen this case. It was a couple of weeks ago. Workday got hit hard for using AI because they screened out people who were 40 and older, and they screened out people for other protected classes. And their argument was that they were doing what the client had configured the system to do, and the court said no. At the end of the day, it's your AI, you're responsible for it. And they've got to go back and notify, I think it's about 40 million people that they may have been discriminated against because of the AI. So it's a good lesson about turning too much over to the machines, at least at this point. And then, of course, everybody wants a leg up in their interview. There's lots of stories out there in the employment world about candidates using AI during the interview to answer interview questions. You see this a lot in tech with programmers and developers who set up a cell phone or another computer on their desk out of camera view, and they quickly punch the question in and hem and haw stall for to answer the question. And then suddenly the perfect answer pops out. That's the answer they give. And of course, they don't really know the answer. So when they get hired, if they do, then they really can't do the job. So It's another interesting angle here and another challenge for hiring managers here. So this is not going away anytime soon. But California is going to regulate it to the degree that they can, assuming this stuff passed. It looks like it's going to pass, but again, there is some opposition to how strict these rules are going to be, that it stifles innovation. So we'll see what happens. It's being debated now in the legislature. And then this is always fun, because I hear this from clients all the time. When I was in HR, I heard this from employees all the time, all these kinds of things, these myths. And certainly there's more than just these, but these are a lot of common ones. My boss bullies me, so that's harassment. No, there's no law against bullying. That's not harassment unless they're bullying you over some protected class. Otherwise, your boss just sucks, but it's not against the law. So my company has to give me required vacation time. Nope, vacation's optional in California, not required to have it. I'm entitled to a paid maternity leave. Nope. Other than SDI, yes, but other than that, you're not entitled to anything else except the leave itself, which is unpaid outside of SDI. I can tell my employees that they have to give me a mandatory notice for quitting. So say 2 months, 3 months, whatever it is. Well, they're at will, and at will is with or without notice. So theoretically, you can give them a mandatory notice before they quit. But what are you going to do if they don't honor it? Are you going to handcuff them to their chair for the next 3 months? I mean, it's not enforceable unless there's a contract with specific terms. Otherwise, if they're at will, no, people can walk out anytime. I can't ask about a specific disability prior to a job offer. You can't get into a lot of details, but if someone clearly has a disability, you can ask questions like, this is what the job entails: lifting, bending, stooping, squatting, whatever it is. Are you able to perform those essential functions? That's a fair question. You're not asking what the disability is. So that's fine. And then certainly after the offer, you can get into more detail if you need to. This one I love because it's such a misnomer, and this is across the country, basically. Salaried means I don't get overtime. Completely false. I've worked in places where people get paid biweekly, non-exempt employees who are salaried, and yes, they get overtime. So it is perfectly legal, and salaried is just a misnomer for exempt, which you don't get overtime. So anytime someone says, I'm salaried, the next question is, well, are you really salaried? Do you get overtime? Do you punch a clock? Do you have a timesheet? Those kind of things. Then we'll determine if you're really salaried. And then if you really are salaried, exempt, let's talk about whether you're properly classified as truly exempt, which in California has a much higher standard than the federal level. And then, well, everybody's at will, so I can just fire people anytime I want. Well, sure, you can, but there's actually so many exceptions in California to at will that pretty much it's meaningless. So you can fire people for anything you want as long as it's not in a protected class or for a protected reason. So you want to just, I have a case right now. You're sleeping with your assistant, and now your assistant is filing a claim against you and you fire her. Well, guess what? That's protected. That's not at will. So yes, at will is sort of a misnomer at this point in California. The only state in the union, by the way, that is not an at will state is Montana. Every other state is at will. But again, in California, it doesn't mean a whole lot at this point. So, and I love this one too. I get this all the time. And it goes back to sort of the mental health slides about, and this is particularly with younger people. My boss looks at me funny, isn't nice to me. This is a hostile work environment, right? No. So hostile work environment is about a protected activity, something you're doing that's protected. My boss doesn't give me promotions because I won't sleep with him. I complained about my salary. So now I don't get the choice assignments. Those might be a hostile work environment. The first one for sure. But just because someone's not nice to you doesn't mean it's a hostile work environment. It's not the colloquial hostile. This is a legal term of art that has a specific meaning, that has specific legal requirements to make it a hostile work environment. And probably 85% of the prospective clients I speak with, and when I was in HR, probably 85% of the employees I spoke with who say, I want to make a hostile work environment claim, when you dig down, it's not a hostile work environment. There may be other issues, but it's not a hostile work environment. That is a very specific thing. And then, of course, in California, we know this is never going to fly. My boss is allowed to tell me I can't work for someone else after I leave, right? Sure, your boss is allowed to tell you that, but your boss can't enforce it. So unless there's a non-compete, and in California, non-competes are very, very restricted to very limited circumstances. So in California, unless you're in one of those very, very limited circumstances, you can work for whoever you want, for any reason you want, anytime you want. Period. End of story. And that's the end of that. I mean, there's nothing to argue about. But a lot of employers, especially smaller businesses, believe that they own their employees even after they leave. So not the case. So that's the end of the formal presentation. Again, a reminder, this is just not comprehensive. It's a general overview. You should talk with a lawyer if you have a specific issue that you want to talk about. And with that, we will open the floor to questions.
All right. So let's start by having people put their questions in the chat. And there's a couple things. You mentioned AI, and is there potentially any ramification if an employee uses AI to create their resume but they didn't read it well enough and some of it was false? Is that something that employees or candidates should really consider?
Absolutely, because just like today, or yesterday, I guess, if you did a resume and didn't read it carefully and falsified it and the employer found out, I mean, and you couldn't do the job, you're going to be terminated potentially,
Mhm.
whether it's AI or not.
Yeah. Okay, so Bill Laser has a question. Can you talk more about protected classes regarding at will? Is there a list of these protected classes somewhere?
Yes, you can just Google California protected classes, but they're going to be generally around race, age, disability, gender expression, marital status, religion, national origin. Those are the big ones.
Okay.
I don't know if I said disability, if not disability.
Yeah, and
Mhm.
you had talked about mental health. So
Yeah,
mental health is a disability,
could be.
right?
Yep.
Or what do you mean it could be? What are the
Well, in the employment context, I mean, everybody in America's probably got some kind of mental health issue at some level. It really is going to depend whether it rises to interfering with the work and whether the person can perform the essential functions of their job. At that
Mm,
point, it's going to become a disability for workplace purposes.
okay.
So, I'm stressed out. My boss doesn't treat me well, and I've just got to take time off. I can't do this right now. Well, if you get a healthcare provider note, that's probably going to qualify for FMLA and CFRA. And if the company's big enough for it, potentially workers' comp, although it's very hard to get a stress claim through workers' comp. And at that point, yes, it would be a disability.
Okay,
For our,
Russ, you have your hand raised.
And I was going to say that I was going to say probably globally, not just in the U.S. Everybody has some type of mental thing where it arises, like you said. And I was asked it in the question thing. Yeah, I guess then hostile does not equal toxic, like in work environment, correct?
toxic is not a legally protected issue in and of itself. The question would be, why is it toxic?
Mm-hmm.
Is there rampant sexual harassment? Is there rampant discrimination? Is there rampant pay equity? Are there rampant pay equity issues? Those could be protected, but the toxicity itself is not necessarily protected. And again,
Okay.
Russ, I think you're not in California, right?
Oh, I'm in Connecticut.
Yeah. So California's got a rule and a law for everything you can think of. So it's probably a little bit different where you are.
Right.
That's why I said at the top, it's like a different country here. So many states just follow federal guidelines, which are actually not as favorable to the employee. Whereas in California, the laws are written, almost all of them. I can only think of one that maybe is pro-employer on the employment side that are very pro-employee and anti.
Yeah, that's interesting. You mentioned about Montana too.
Yeah.
Anyway,
Okay,
not
before we go to Ellen, Carla writes a question. What can be negotiated in the severance package?
Anything can be negotiated in a severance package. Whether there's a receptiveness to doing it is another story. And I think you don't want to try to negotiate so much that you end up with them just pulling a severance package or significantly downgrading it, because unless it's contractually obligated, the employer has no legal obligation to give you a severance package. The reason, I'm just going to be blunt about it, the reason they're offering you a severance package isn't to help you land on your feet, even that's what they tell you, or to help ease your transition. It's to get you to sign that severance agreement so you can't sue them. Now, in California, there are certain things that can't be waived in a severance agreement. But that's okay. They're still going to be in the severance agreement. And if you sue over it, what the severance agreement is likely to say, if it's well drafted, is that, well, if you go ahead and file complaints with what now it's called CRD or the EEOC or some other administrative agency, that's fine. We can't prevent you from doing that, but you're agreeing here that you can't accept any monetary damages that come from that. So essentially, even though you can't waive it, you've essentially cut off your ability to really benefit from it. I mean, that's the way around it. So they're buying peace. That's what they're doing. Now, if you have a truly altruistic boss, maybe they also care that you land on your feet. And those things, I'm not saying it's 100% of the time, but the reality is these agreements are really more for the employer than for the employee.
Oh, that's interesting. Okay, Alan, question.
Michael, great presentation so far.
Thank you.
My question is really around the application process, and we've all filled out applications. And as you get to the bottom of the application, there's a bunch of boxes to check in terms of, are you a veteran? Do you have any of these health-related issues? There's another third one I can't remember right off the top of my head, but I'm curious, what happens with that information? Where does it go? And do you see that information will continue to be collected on all of us moving forward as we go through the application process?
A lot of questions. So let me know if I miss any of them. So in California, there won't be any health-related questions, but there will be questions about veteran status. Potentially, do you consider yourself to be disabled? That's probably as far as it's going to go on health. And what your race, gender is. And in California, again, I think, Alan, I don't think you're in California, right?
No, I'm in Phoenix.
Yeah. So, and Phoenix doesn't have a whole lot of employment laws. So, Arizona. So that's about all that's going to happen in California. That information is generally gathered by companies who have federal contracts, or in some cases, state or local contracts, because they have to meet EEO requirements. And so that data helps them collect that they're being a fair employer, that they're recruiting from a cross section of society, and all of those sorts of things. The data, if the systems are designed right, is never supposed to be seen by a hiring manager or anybody in HR, except for the person who's reporting out on that data, who is not involved in the hiring process. Does that happen in real life? Sometimes. Sometimes it is shared, unfortunately, but the idea is that it's not supposed to be shared. With the change in the administration, whether federal contractors will still be required to collect that data is an open question. Federal contractors in California have been told that California law requires them to collect that data, irrespective of what Washington, D.C. has to say. So in California, they will continue to collect this information. Most of these executive orders, other than cutting funding, have no effect in California, because California law provides for the same thing.
Great. I appreciate it. Thank you, Michael.
Yeah.
Okay, Tammy has a question. Can you provide some general tips for one-way and gamified interviews? It's not always clear what will be done with these recordings or if AI will be screening them.
You can always ask. And in California, we have the CPRA. It's the old CCPA. You have the right to any data they collect on you. So afterwards, if you don't get the job, you can always ask for that data and they have to give it to you. So that law talks about consumers. And in California, consumers include employees and job applicants. So that is your data. I mean, you can actually even ask them to delete it if you'd like. I don't know that you're going to get a direct answer about what they're doing with it. They may or may not tell you. I suppose it depends on the position. I mean, if you're doing software development, that might be a fair question. Hey, this is really kind of cool what you're doing. Can you tell me what you do with it? But as a sales executive, I don't know that might be kind of an odd question to ask, and they may not be ready for it. And I think when you're looking for a job, you might not want to ruffle too many feathers, at least early on. So,
yeah, Tammy's in New York. How does New York compare with California?
I'm not familiar
pretty
with.
Close.
Yeah, New York is getting closer to California. I don't know that they necessarily have a CPRA-like law off the top of my head. I think there is some form of a privacy law in New York. I'm not licensed in New York and don't practice there. So I don't know offhand, but I certainly can refer you to a couple of employment lawyers in New York or who service New York. If you like, you can just reach me offline and you can certainly reach out to them.
I think why I asked is because it's not always explicit. You know, they're going to keep it just until the duration of the interview cycle and they're destroyed. I mean, are these going to be played, you know, during the lunchroom or something? Are they going to be using it for training purposes, whatever that means?
They
And,
may.
you know, whenever you do a video, I mean, it's a potential for identity theft. You know, they have
That's right.
your face and your voice print. And so it is a concern for me as he's become more and more popular. And the other thing is I haven't done it, but it's really these gamified interviews where it looks like a game and they tend to, as far as I know, it's mostly like junior investment bankers do these all the time. And I think there is some rhyme and reason to it. You know, sometimes they ask the same question in multiple ways just to see if you're consistent. But I often wonder too, like what happens, you know, how are these used to screen you in or out? And if AI is going to be there in the back end, and AI is terrible when it comes to video and interpreting everything from cultural norms and all that stuff. And so
Right.
if people are using these as like lie detectors because they didn't look up and to the left when they were recalling a memory, you know, or the body language and all that stuff,
That's
it
right.
just makes me, I mean, if people can get that wrong, I know AI can get that wrong.
And that's part of the reason why California has this legislation pending now to really uh, crack down on, not that you can't use it, but there's got to be human involvement before any decisions are made to double check it. That's going to be the check. Now, whether people really do that is another thing, and it will take a series of lawsuits probably over the next 10 years or so by the time they get resolved to figure out what the guardrails are on there. So in New York, I think you probably ought to, I mean, again, I can refer you to a couple of lawyers there. Think about whether they have such a law, and if they don't, probably contact your state representatives and ask them to, think about this and maybe look at California, which they're doing more and more anyway, to say, hey, maybe we ought to do what California's doing. And this is all coming in California from GPDR in the EU.
Oh, interesting.
That's what got this California thing going with the whole privacy thing, which then turned into, hey, we probably ought to look at this AI stuff too, because there's a huge issue with data and identity theft and decision making.
Interesting. So I have a question. If somebody is employed by a California company and they're based in, say, Phoenix or New York, which law prevails?
California is likely going to prevail.
Okay. Okay. So there's a few more questions. So
And
Jane asks,
can I add to that too?
yes.
So California's got this really interesting law. It's been challenged in some other states. A couple of states have said, no, California's overstepped. It hasn't been fully resolved yet, but California's got this law that basically says too, that if you sign an arbitration agreement from a California employer, that arbitration agreement works nationwide. We don't care what you do in your own state. California law rules, and some state courts in other states said, no, California, your long arm is too long. You don't get to tell us what to do in another state. Some courts have said, well, the employment arrangement was made in California, so we're going to honor the California law. And California actually outlaws in any kind of employment arrangement, including an arbitration agreement, a choice of law that is not California, no matter where you're employed, if your company is in California. That's what
That's
home base
interesting.
is. It will not be enforced.
Okay. 3-month commission guarantee. However, it stated it was recoverable if employment ends within 12 months. Can this be enforced even if the company misrepresented their commission potential?
So this comes up a lot with commissions and these kind of pay plans. Recoverable is allowed. You're looking for whether or not you ever got paid below the minimum wage. Unlikely, but possible. Or was there some other consideration that would render that deal unenforceable? But recovery by itself is enforceable.
Okay. Well, yeah, it seems unwise for the company to even go after that, especially if it's only a 3-month recoverable.
How much did you make?
Is or is not? I'm sorry, I didn't hear that. Is not enforceable?
It is enforceable, but
Yeah.
It is
again,
enforceable.
but to Christie's point, why would I mean, in 3 months, how much have you really earned in commissions? I mean, you're getting up to speed with the company. You're getting to know your customers, or you're building your book. I mean, how much have you really earned? What are they really going to recover? I mean, right?
Yeah. Well, exactly. And yeah, you're right, because you are working. Yeah.
Yeah.
So yeah, we've taken a look at that with an employment lawyer before, and it's really, really tough.
What'd they say? I'm just curious.
Well, it wasn't this exact thing, but we don't have a recoverable, but it's recoverable against future earnings. We never
Sure.
said it's recoverable with if you terminate.
Yes. Oh, I see. I see the distinction
Yeah.
you're making. Like it's a draw, essentially.
Well, it is a draw, but if the employee, I mean, we would never put in one of
Sure.
our contracts that it was recoverable upon termination within a certain period of time.
Right. I mean,
I
I
just
guess if
think that's
I guess
wrong.
if I were
It's yeah.
I guess if I were, taking the job and saw that, I might give pause to, do I want to work for this company if they're
Exactly,
really
exactly.
this bad?
That's okay. There's a couple more questions. Are you
Yeah.
obligated to disclose your last salary, even show your prior W-2 as proof to a new prospective employer if they request it when negotiating salary?
The answer is no and yes. So during the interview process, no. Once an offer has been made, yes.
Oh, interesting. Okay, so many conduct assessments before hiring under the guise of future coaching, but use in hiring decisions, which cost them dearly once it's out in the open.
I'm not sure I
Wait,
know.
Oscar, why don't you come on mic and
Hi, good. Hi, everybody. Thanks, Christy. What I was saying was that the experience I've had both in California and other states that we operate in is that a lot of these companies will do like the Bristol Myers, like all these different assessments, and it's under the guise of, hey, we just want to get to know. So when you're assigned to your manager, et cetera, well, when it's come out in the open that they made some hiring decisions based on these assessments, that's when I was saying it cost them dearly. And I'm not sure where it stands now. My experience with this was a few years back.
How did it cost them dearly? What are you referring to?
Because I made hiring decisions and then ended up not hiring the individuals based on the assessments. And there was documentation showing, hey, this person did this or scored this way. Really don't want to bring them on board.
Oh, it cost the applicant dearly, not the company. Yeah. So, this is an ongoing debate about assessments. So as a general matter, anybody who's using assessments has got to use assessments that are reliable and valid. They can't just make something up, which a lot of companies do. So something like a Myers-Briggs predictive index, DISC, these kinds of things, these are reliable and valid. They're commercially appropriate things. Now, to use them not to hire, sure, it happens all the time. And that the use of the assessment is legal. Whether the use of the assessment to not hire somebody is legal depends on what they found in the assessment, why they didn't hire them. So if it's a protected class issue, then it's not legal. If it's just a culture fit legitimately, that is legal. I can tell you, in one HR role, I used predictive index at the urging of the CEO, who was really wowed by it. He got some sales demonstration and just said, let's try it. And I got to tell you that it was about 98% accurate in terms of matching potential employees to their managers and overall company fit. And it was amazing. Now, the Myers-Briggs, that's a personality test that I personally have real issues with that. I think that's too far. That's a bridge too far, I think, to go. You're going to find out things that you don't really need to know. So I would caution an organization not to do that.
Okay, Bill asks, if your company is headquartered in Florida, but you work in California, can they say you are not eligible for CalCobra when laid off because they are headquartered in Florida?
You're paid here and your deductions are here and everything is here. You're eligible for CalCobra if you're otherwise qualified for it.
Okay, that's good to know. Yeah.
Yeah, it's interesting. It didn't happen.
Oh, wow. Gosh, Bill. Okay, Tammy has another question. Can you comment on the erosion of non-compete clauses, the prohibition of discussing salary and other norms that were common earlier in her career?
Well, I can comment from the California perspective. It's been in California, I think it may even go back further, but I want to say the 1940s. It might, like I said, it might even be older than that. The California has had a very strong policy against non-competes. California believes that workers should be able to earn a living in their chosen field without restriction. And it's another very pro-employee kind of thing. Again, there are some limitations on that. They're very few and they're very specific.
Aren't they like trade secrets? I mean, that's really.
Well, trade secret's a little bit different, but it's related, yes. So,
Mhm.
for example, Christy, if you sold PRG tomorrow, right, to me, I could put a non-compete for you in place for some period of time because I'm buying your business. And so if you competed with me, you would undermine my purchase of your business because all of your clients would come back to you. That is an exception in the non-compete. The sale of a business, the breakup of a partnership, something like that, right? But other than that, there's three. I can't remember what the third one is off the top of my head, but that's it. Everything else is open season. Now, the argument is often made that we need a non-compete, to your point, Christy, because there is a trade secret issue. So that opens sort of a can of worms. So you can protect trade secrets by giving people a trade secret agreement that says these you can't take. What often happens, and it becomes a problem for organizations, is they identify everything as a trade secret. Well, a trade secret has certain definitions. And so a lot of those things we see often are really not trade secrets and not protectable. Sort of the sort of anecdotal rule of thumb is if I can find it on Google, it's not a trade secret. So, a customer list. If I can find out that this person is your customer on Google or some other public source, it's not
Oh,
a customer's not a trade secret.
yeah, that's interesting.
But
That's interesting.
But if you do have legitimate trade secrets, some kind of process, that you're doing in engineering or some kind of, the Coke formula, right? Then you give the employee at hire a list of those trade secrets and have the employee sign off. These are trade secrets there. You cannot use them in any other firm. You cannot share them with anybody. That's permissible, but that is not a non-compete. So if I'm at Coke and I know Coke's secret formula and I go to work at Pepsi in California, that's okay. You can't stop me from doing that. You can, though, enforce that trade secret agreement that I signed.
Interesting. Okay, and Camilla asks, and you've already answered it, I think mostly, but I just want to make sure.
Yeah.
Are you obligated to disclose your last salary and even show your prior W-2?
Oh, I'm sorry. After the offer is made, they can ask about your prior salary. It just can't be used in the hiring decision.
Oh, okay. So
So, yeah.
salary negotiation is really before the hiring process, right?
Right.
Yeah, so they can't ask for it
No.
during the negotiation process.
And frankly, I wouldn't give them a W-2. It's got, unless you're going to redact your social and everything. They don't have a need to do that. And frankly, it's none of their business. And the argument I would make as a candidate is, you know what? This is a different organization, even if it's in the same industry or the same type of role. It's not apples to apples. Every organization is different, and what was there and what is here, it's completely irrelevant. If I made $2 million here and made 100,000 a year, it makes no difference. We're talking about this job in this organization.
Right. And that's a really good point because it's not about, yeah. And there are companies that are known to underpay.
Absolutely.
And so it's not relevant.
And I know some of this is hard to hear when you're looking for a job because you got to get that job to keep food on the table and a roof over your head, and you're going to do whatever you need to do to get the job. I've been there many times. I understand. But don't burn yourself in the process. Right?
Yeah. Well, in addition, is that if a company is going to press for that, is that really a company that you want to work for?
Exactly. This is part of that
yeah,
onboarding
but to your
culture.
point, people want to work. So,
Right.
it's like a tug of war almost.
Right.
And then Hope asks, is this specific to California or more broadly?
Which is what specific?
The asking for proof of pay.
California's got a law. I think a couple, maybe 3 or 4 other states have a law. I think actually New York might have a law about asking for salary history. You can just Google your state and see if there's a law against asking for salary history. It is not widespread yet. Part of this also has to do with the requirement that people post legitimate salary ranges in job ads. And in California, the problem has been people are posting ranges like 200 to 600. Well, That's not a legitimate range. And New York has actually followed California and did this. And they've actually amended their law to say it has to be a legitimate range and there's some percentage on it of the spread. It has to be, so that you can't do that. In California is looking at modifying its law because it's not serving its intended purpose for people that don't comply. People that comply, fine, but it's sort of misleading. And there was a question I don't think I answered about the non-compete erosion. So Congress is considering, although under the current administration, I don't know if it'll go anywhere, is considering a federal nationwide ban on non-competes, absent certain exceptions, pretty much mirroring California's, because it is limiting labor mobility. And is it really necessary now? Because you can protect trade secrets, as we discussed, separately, and that's fine. And that's usually what the real issue is about. In some states, think the Deep South, there's a lot of issues around non-competes because companies think they own their people forever. And they go on forever. And we're going to decide if you leave us where you're allowed to work from now on.
Oh, wow.
There's a lot of abuse. There's a lawyer in Florida named Jonathan Pollard who made a career. He's a young guy. He's made a career out of defeating these for bogus reasons like trade secrets. And my line about if you can find it on Google, it's not a trade secret, that comes from him, actually. So, and the federal government took note of what he was doing in Florida. And that's how Congress got involved. And he's been on a lot of, CNN, MSNBC, all these places of a business.
He sounds interesting.
So
Okay, one last question, then we have to cut.
Yeah,
But are there any guidelines regarding employee benefits in California, specifically start date? Like what's the delay or start date?
There's no specific California rule. There's ACA rules around it. So 90 days is generally accepted as the furthest you can go without having benefits. But again, is that an employer you want to work for? I understand that putting somebody on benefits and it doesn't work out and it costs a lot of money. But do you want to work for somebody who's going to make you wait 90 days and pay for COBRA or pay for something on the exchange or whatever? Does it make sense? Especially at the level that I think all of you are probably at in your career. I mean, why would you do that?
Yeah, no, that's interesting. Well, Michael, thank you so much. Can
I add one thing to the benefits?
Yeah, please.
So, however, California does have a rule. It's been in effect for, I want to say, about a year or maybe 18 months, that all employers in California must offer some kind of retirement plan. So if they offer one, great. If they don't, they have to join Cal Savers or go out to the private marketplace and offer one. Small businesses have an exception or an exemption until I think it's either December 1st or 31st of this year. But after that, everybody in California, one employee or more, must offer a retirement plan. Employees can opt out of it, but they must offer it.
Quick follow-up.
Good. All right. Well, this has been really, really helpful. Michael, thank you so much.
Thank you.
And we know that we want you back because these are always important questions. So if you're okay with that, we're going to invite you back. So
sure. Thank you for having me. Yeah.
And good luck with your practice. We're going to pass along your information. And are you going to allow the slides to go to?
Sure, if you'd like to. Yeah.
Okay.
You don't have to.
Let's go ahead and send out the slides. We'll send out your contact information. Reach out to Michael. He is so helpful. And so, boot camp community, this is your guy. He's a former boot camper. So thank you, Michael. And next week we have Brad Hayden, who's going to talk about creative ways to use AI. And he will specifically address like job search. And so we're really excited. Brad is a former boot camper, also is a CEO of an AI company. And so we've got, Oscar, who's in the house and an AI expert, and Brad. We're going to have we have lots of AI experts that you can tap into. So thank you again, Michael, and hope we see you all next week, and enjoy the weekend. Be safe, and goodbye from the East Coast. Bye, everyone.
Bye,
Bye-bye.
everybody.